Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the Indian family laws. The working of the Guardians and Wards Act holds great importance when it comes to questions asked in competitive exams. Before getting into the provisions of the Act, let us understand a little about the applicability and effect of the Guardians and Wards Act of 1890. The Guardians and Wards Act of 1890 is the only non-religious universal law regarding the guardianship of a child and is applicable to all of India except the state of Jammu and Kashmir. The Hindu Adoption and Maintenance Act was applicable solely to the Hindu society. There was a need for another law that was sensitive to the personal laws of other religions. This gave rise to the Guardians and Wards Act of 1890. This was particularly outlined for Muslims, Christians, Parsis, and Jews, as their personal laws did allow for full adoption, but only guardianship. It is applicable to all children regardless of race or creed. Section 4, Clause 3 defines ward as a minor for whose person or property or both there is a guardian. It establishes a relationship of a guardian and a ward but does not confer the status of a natural child. And when the ward turns 21 years of age, they assume individual identities. They also do not have an automatic right to inheritance. Section 7 of the Act empowers the court to make orders to remove and appoint guardians for the welfare of the ward as well as his property, and where the court is satisfied that it is for the welfare of a minor, it may appoint a guardian of his person or property or both. An order under this section would imply the removal of any guardian who has not been appointed by will or other instruments or appointed or declared by the court. And where a guardian has been appointed by will or by the court, an order under this section appointing or declaring another person to be a guardian in his stand shall not be made until the powers of the guardian already appointed under this provision of the Act have ceased. Section 15 of the Act deals with the appointment or declaration of several guardians at the same time. If the law to which the minor is subject admits of his having two or more joint guardians of his persons or property or both, the court may, if it thinks fit, appoint or declare them for the welfare of the child. Separate guardians may be appointed or declared of the person and of property of a minor if a minor has several properties. The court may think fit and appoint or declare a separate guardian for any one or more of the properties. Section 17 of the Act lays down the matters to be considered by the court in appointing the guardian. The court shall be guided by what appears in the circumstances to be for the welfare of the minor, and must be consistent with the law the minor is subject to. Some of the factors taken into considering the welfare of the minor are the age, sex, and religion of the minor, the character and capacity of the guardian, and his nearness of kin to the minor, the compatibility quotient with the guardian, the wishes, if any, of a deceased parent, and any existing or previous relations of the proposed guardian with the minor or his property. And if the minor is old enough to form an intelligent preference of his own, the court may consider that preference. The court shall not appoint or declare any person to be a guardian against the will of the minor, in consonance with Section 6 of the Act, which states that nothing in this Act must be construed to derogate from any power to appoint a guardian of his person or property or both, which is valid by the law to which the minor is subject. Section 19 of the Act lays down certain cases in which a guardian is not to be appointed by the court. The court is not authorized to appoint or declare a guardian in the following cases: of the property of a minor whose property is under the superintendence of a court of wards, of the person of a minor who is a married female and whose husband is not, in the opinion of a court, unfit to be a guardian of her person, of a minor whose father is living and is not, in the opinion of court, unfit to be guardian of the person of the minor, of a minor whose property is under the superintendence of a court of wards, competent to appoint a guardian of the person of the minor. Section 22 of the Act provides for remuneration of the guardian. A guardian appointed or declared by the court shall be entitled to allowances fit for his care and pains in the execution of his duties if the court thinks it fit. Section 24 deals with the duties of a guardian of the person. A guardian of the person of the ward is charged with the custody of the ward and must look to his support, health and education, and such other matters as the law to which the ward is subject requires. And Section 27 prescribes the duties of a guardian of property. A guardian of the property of a ward is bound to act as a man of ordinary prudence would, as if it were his own, and has the authority to do all those acts which are reasonable and proper for the realization, protection, or benefit of the property. Section 39 of the Act deals with the removal of the guardian. The court may, on the application of any person interested, or of its own motion, remove a guardian appointed or declared by the court or by will or any other instrument for the following causes: for the abuse of his trust or for continued failure to perform the duties of his trust, for incapacity to perform duties of his trust, for ill treatment or neglect to take proper care of his ward, for continuous disregard for any provision of this act or for any order of the court, for conviction of an offence implying, in the opinion of the court, a defect of character which makes him unfit to be the guardian, for having an interest adverse to the faithful performance of his duties, unless the adverse interest accrued after the death of the person who appointed him, or it is shown that person made and maintained the appointment in ignorance of the existence of the adverse interest. In the case of a guardian of the property, for bankruptcy or insolvency, by reason of the guardianship of the guardian seizing or being liable to seize under the law to which the minor is subject. Section 40 of the Act provides for the discharge of the guardian. If a guardian appointed or declared by the court desires to resign his office, he may apply to the court to be discharged. Or if the court finds that there is sufficient reason for the application, it shall discharge him, and if the guardian making the application is the collector and the state government approves of his applying to be discharged, the court shall in any case discharge him. I hope this video was helpful in providing a simple and clear understanding of the Guardians and Wards Act of 1890. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to the channel.